When I started out doing this area of law more years ago than I'd like to recall, uh, the guardianship law was very complicated. There were three different statutes, there were three different standards. Nobody could figure out which statute to bring a case under. In the mid 1990s, a group of attorneys and commissioner of accounts were brought together. I was one of them. I think there were about 20 of us. And we sat down to redraft the Virginia guardianship statute. And after about a year's work, we came up with a draft. It was submitted to the General Assembly. The General Assembly certainly made their changes, but to a certain extent, kept the general ideas and a lot of the same language. Basically, what that statute did was it created a single standard for incapacity. So there would be no more three different statutes. There would be one statute that would define what would be incapacity. We'll get to that in a moment. Second of all, it also laid out certain things that had to be in a petition. And we'll take a look at the statute as to what has to be in a petition for guardianship conservatorship in a moment. Thirdly, it specified duties for the guardian ad litem. We'd always had to have a guardian ad litem, but nobody was really sure what was the role of the guardian ad litem. Some people took the position that the guardian ad litem was to be always the respondent's attorney and took a more aggressive role in challenging the guardianship. The new statute, or the statute that was enacted, changes that and makes the guardian ad litem an advisor to the court, and the guardian ad litem can, if they wish, ask the court to appoint separate counsel for the alleged incapacitated person.